Phil Brunner here, Bailiwick Legal. Um, so just a disclaimer to start with. The information contained in my presentation orally is provided for information purposes and should not be relied upon as legal advice. So just take that into account whilst we go through my discussion today. So Bailiwick Legal, hopefully most of you know who we are at the moment. We specialise in agribusiness and tourism as industries, and we deal with composite law across those two sectors and other sectors. What people don't tend to understand or realise is that matters within law cross different sector boundaries. The legal principles remain the same. Anyway, coming to today's discussion. Over the last couple of years, there's been an increase, particularly in relation to mineral exploration and, whilst I'll say oil and gas, the predominant exploration activity onshore is gas rather than oil. And so there's been an increase over the last couple of years in that activity. Particularly in the southwest region. That's really from, say, Gelton through to Albany in that particular area. And of course you've got the mining sector, towards Southern Cross, Kalgoorlie and beyond in the pastoral regions. So we've been getting a lot of queries more recently, and I thought it would be an opportune time to discuss these issues in the interest of the farming community. So many landowners seek our advice and assistance to get an understanding of their rights and their options when they're approached by a company seeking access to their land. And it varies a little bit, but generally most farmers are becoming a bit more wary about simply signing away their access rights on a short piece of paper that's initially presented to them by the mining company. And of course, there is a conflict here between the mining company's access opportunities and rights and the farmer's rights and access to the land for its operational purposes. So from time to time there is conflict between those two parties. When we get to the discussion on access rights and regimes, we can really bring this down to probably two major components. That is mining, governed by the Mining Act, and oil and gas, which is governed typically by the Petroleum and Geothermal Energies Resources Act. Bit of a mouthful there, but if we just call it the Petroleum Act, everyone's happy. Amongst those primary two headings, we have subheadings which are particularly relevant to the Mining Act, what is called private land, which effectively is freehold land, and what we call crown lease or pastoral land. So if we look at mining initially as the first place to start, and we deal with agricultural land in that setting, the very first point that is relevant for farmers within the agricultural sector is they have what has historically been called a right of veto. And that means that a farmer farming agricultural land, and whether the critical point here too is that it doesn't matter whether this farmer is the owner of the land or in occupation of the land. I won't go into detail as to the distinction there, but suffice to say, owner-occupier, let's bundle them in for today's purposes as one and the same thing. The owner-occupier has, when it comes to agricultural land and mineral exploration, a right of veto, which means that the owner-occupier can simply say to the mining company, no, I don't want to grant you access to my land, and that's it. Nothing the mining company can do. Right? And more, I have to say, more and more farmers are becoming more and more wary about having that type of activity being conducted on their land, and the flow-on effects that might follow over the course of time due to that impost. And a lot more farmers are actually saying no. And as I said, there's nothing the mining company can do. There's no mechanism under the Act which allows any other entity, including the relevant minister, to actually impose a mining company on you as an agricultural landowner. In relation to exploration rights, now, and I'll flip here a little bit, if there has already been granted access by a mining company, that's a different scenario again. I'm not necessarily going to cover that. But if you have already granted rights to a mining company and you need advice in that context, please give us a call and we can help you through that. So, if a farmer, owner-occupier doesn't necessarily have an issue with a mining company coming onto their land for exploration purposes, what we advise is that what's called an access and compensation agreement is typically entered into, and care again needs to be taken in relation to these agreements. We've seen a whole plethora of agreements, from a single one-page document to something that might be 20 pages long. There's no right or wrong, although there are some particular parameters that farmers particularly need to be very wary of. A couple of those are, what's the term of the access? How long are these people want to access the property? What compensation are they going to be paying for the right to access the land? What are the biosecurity issues that are going to be maintained or implemented, and when is the access proposed to be? Is it going to actually interfere with the farming operations? And that flows again into the issue of compensation. So under the Mining Act too, there is a register of tenements, is what they're called, held by the Department of Mines and Petroleum. And in the context of mining, what's written in the register is seen to be judicially and administratively important, in the sense that a court and the administration takes note of what's in there, and aside from fraud and a few other exceptions, what is on the register is the true and accurate record. Now that has certain ramifications if you've already entered into or already consented to access to your land. The fact that your land's on the register has ramifications longer term. It means that the mining company could flip their exploration license into a mining lease and not have to re-engage with you in the context of negotiating further compensation. So there needs to be some care in putting these agreements together for exploration purposes, because if they're not done properly the first time, there can be some very expensive and costly ramifications down the track. So that's freehold land, or private land as it's known in the Mining Act. Then we can look at the other major type of land holding that's governed by the Mining Act, and that's Crown land, pastoral leases in particular. So again, the owner and occupier of a pastoral lease does have certain rights. I have to say that by and large, my experience lately is that most pastoral lessees and owners don't actually realise that they have rights under the Mining Act with respect to access and compensation. Typically what we've seen recently is that pastoral lessees have simply let mining companies onto their land without any access agreement and without agreeing any particular regimes for that access as to when it's going to happen, where it's going to be. Are they using roads? Are they destroying fences? Are they putting cattle grids in? And are they paying some compensation for that access? So it's important for pastoralists particularly to understand that they do actually have some rights under the Mining Act in relation to allowing access for a mining company to undertaking exploration. It's not the situation where these companies have a carte blanche access right. They don't. Admittedly, the rights of a pastoral lessee are not as composite or comprehensive as a private landowner, but they still nonetheless have rights. Again, what we've seen in the pastoral area of late too is a bit of a quirk. Some people might be aware that the Commonwealth has an emissions reduction fund, which is a pool of money available for pursuit of carbon credits and regeneration ag, which is what it's commonly called. So in WA, recently, I guess over the last couple of years, we had a situation where pastoralists are trying to access this carbon credit concept and to undertake regeneration vegetation, but have actually come across a bit of a stumbling block with the state mining system, which really has, I guess, attempted to put the mining entity above the revegetation environmental protection issue. That's a policy decision for the state, and it's an issue that pastoralists would need to deal with as well as part of the access regime. So let's move from mining across to oil and gas, which is completely different again. It's a different piece of legislation, there's different rules that apply, and under the oil and gas legislation there is no real distinction between private land and pastoral lease or crown land that is given to pastoral lease. Pastoral lessees, as an owner and occupier of that land, or I should say an occupier of that land, are probably going to have similar rights to a freehold land owner. Now, this is said in the context that there's been no decisions that we're aware of within WA and even across the state dealing with access and compensation rights to landholders vis-a-vis gas exploration companies. By and large, access rights are negotiated. There is no right of veto for farmers in relation to gas and oil exploration activities. And if the parties cannot reach agreement in respect to access and compensation as part of that process, then either of those parties, the oil and gas company or the landowner, can go to the magistrates court to seek a determination on compensation that's payable. Interestingly, over the last, say, 12 years, there's probably been maybe half a dozen cases commenced in the magistrates court for the determination of compensation, and none of those matters have progressed to a trial. They've all been resolved one way or another, and typically through an access and compensation arrangement. So in the context of oil and gas as well, some years ago, I think probably around 2014, the APPEA, Australian Petroleum Producers and Explorers Association, WA Farmers, Pastoral and Graziers Association and Veggies WA spent the best part of 12 months, I think, negotiating a template access agreement. And so if it comes to this situation, farmers can be aware, or need to be aware, that a lot of the work in respect to access rights and a balancing of those rights has already been done through the development of that template access agreement. And if you need assistance with a gas explorer seeking access to your land, please come to us and we can have a look at that agreement and see whether it suits you. As I said, where there's a dispute about access and compensation, companies can commence an action in the Magistrates Court for a determination of the compensation. In the context of both mining and oil and gas exploration, invariably there's interaction with other laws that are sort of part and parcel of the process for a mining company to move through the system and actually get to do what they want to do, you know, whether that's exploration or whether that's mining. So even in an exploration context, companies usually have to get over a hurdle of filing an occupational health and safety plan. They often, invariably, particularly in pastoral areas, need to deal with Aboriginal heritage issues. And there is, you know, becoming more and more imperative to deal with cultural issues within the Aboriginal heritage system as well. There's also environmental protection impacts. So farmers typically have to make application to clear more than 5 hectares a year of bushland. Same rules apply to mining companies. In the context of the application, the same rules apply. It seems, though, bit of a dig here, but it seems, though, that mining companies are much more able to get a tick on clearing applications than farmers are. Enough said there. So those laws do overlay things. If it comes to mining, let's say we've gone past the exploration stage and we're into a mining profile, mining companies also need to file a whole raft of other plans for approval. And one of those plans during the course of time will be a mine closure plan. I suspect one of the issues that we grapple with at the moment in this sense is that you know, I travel around the agricultural sector through the southwest of WA, and invariably in certain you know, parts of the southwest, and I can think of perhaps Ravensthorpe as a good example, there are pits, you know, mine pits all over the place that are invariably quite deep holes that invariably fill with water. And they're all fenced off, that's well and good, but there's still a safety hazard and there's still a blight on the landscape. Now, it's clear to me at least, and again a bit of a dig here, a bit of a controversy I guess, is that we don't, as a government here, there doesn't seem to be great emphasis on rehabilitation. You know, we can look at what happens in the northwest for iron ore mining and the rehabilitation of land. We can look at perhaps Alcoa's operation in the foothills here and look at how they've been progressing with rehabilitation. But a lot of these other miners that are sort of digging deep holes, you look at Kalgoorlie and the raft of holes that are out that way, there doesn't seem to be a great impetus to push or force rehabilitation to perhaps the degree it ought to be. Such that you know, we've been involved in a dispute where a farmer's had a 40 hectare salt lake left on his land post mining operations, and that of course creates all sorts of degradation and an inability to use that land for agricultural purposes, and that's an issue. You know, longer term, that salt lake's not going to disappear quickly, and you've got the productivity loss from that land for a very long period of time. So that flips me back to the access and compensation agreements. It's very important that you get those right in the first instance, because often they will drive the compensation regime that might last another 25 to 40 plus years. So that's a bit of a snapshot, very superficial, very generic snapshot of rights and options available to farmers typically, and pastoralists in relation to mining and gas exploration. As I've mentioned, we've dealt with a vast array of these over the course of my involvement in agriculture. Not everyone is the same. Unfortunately, you can't necessarily just take a template access agreement off the shelf and use it for someone else. Most farmers, invariably, every farmer has their own little quirks about how they do things, when they want to do things, and how they value their land. So we try to provide our advice and assistance based on our experience and the realities and practical outcomes that the farmer wants to achieve. So we value the personal approach and practical application of the law and our experience to help individuals deal with those situations. So feel free to reach out to me. We do provide 30-minute consultations generally at no cost, and if you're in that situation where you need advice, you're either being approached by a company or you have already signed an existing access agreement, and you need some advice in relation to those things, call us and put your mind at rest and let us help you. Thank you very much. Keep safe and well.